Today, our endeavor would be to find out or appreciate the consequences of circulating a statement without mentioning the context in which the statement has been made. Now, the discussion is relevant because we can see that at present the media is circulating a statement which has been made by, which they say has been made by one of the sessions court in Kerala, where they say that the court has stated that a complaint of sexual assault will be invalid if the woman was wearing sexually provocative dress at the time of the commission of the offense. Now, the media does not mention the context, the factual narration based on which the court has stated this, but I must say that the court has not exactly stated or not used the words which the media is stating that the court has stated, and the court has stated something completely different, and I shall read out what the court has stated presently. Now, the context is very important. For example, if I am being slapped by my father in front of my relatives, it is one thing, and when I am slapped by my father in private, it is another thing. Now, the act is same. The act is that my father is slapping me, but the situations, both the situations are completely different from one another. In the first case, there may arise a question of my self-respect or ego, but in the second case, when I am being slapped in private, there may not arise a question of my self-respect or ego. So we have to appreciate the context to understand the consequences of a statement. Now, the session court in Kerala has made some observation based on a factual narration, and the factual narration is something like this. On 8 February 2020, it has been alleged that a woman has been forcefully taken by a man who has made that woman to lie in his lap, and then the man has pressed the breast of that woman. Now, this incident allegedly has taken place in 2020, but the complaint has been registered on 29 July 2022. So therefore, there has been a substantial gap of 2 years between the alleged date of the occurrence of the event and the date of the complaint. Secondly, the man is of 74 years old, the accused man, and the victim woman is of 30 years old. Thirdly, the whole incident has happened on a beach. Now, the accused did not invite the women to come on the beach. It was some other friend of the women who told her to come on the beach. Now, that means that the accused did not know or was unaware of the identity of the whereabouts of the women. Now, the woman was accompanied by her boyfriend. Now, that boyfriend is also an educated man who is a professor in a college. Fourthly, the court has stated that the accused man is having two daughters. One is a deputy collector and another one is an assistant professor in a college. Now, is it possible, the court says, is it possible for a man having two daughters to sexually assault, to press the breast of a woman? I don't wish to express any opinion on this factual narration. I leave it to my viewers to form their opinion. Now, I will straightway come to the legal provision which is involved or which are involved in this case. Now the case has been registered against that accused man under section 354 IPC, section 354A and section 341. We shall focus on section 354A and section 354. Now the court has quoted section 354A. Now we have to understand the difference between section 354A and section 354 to understand why the court has not appreciated so much section 354 but has appreciated so much section 354A. The ingredients that are needed to make out a case under section 354A is that a man is coming into physical contact with a woman or is requesting the women for sexual favors. This is the ingredients, the acts that a man shall commit to come under section 354A. Now, this section doesn't mention that whether the man is doing such act to outrage the modesty of the women or not. However, section 354A says that to make out a case under section 354, a man shall apply criminal force in an intention to outrage the modesty of the women. So therefore, here you have to prove that there has been an application of criminal force. Now section 354A says physical contact with the women. Now application of criminal force and application of physical contact is not same, because physical contact can be a mere touch, but criminal force means substantial force which you apply by which a person can get hurt. So the court has stated, and I quote the court, paragraph 10, the photographs produced along with the bail application by the accused would reveal that the de facto complainant herself is exposing to dresses which are having some sexual provocative one. So section 354A will not prima facie stand against the accused. Now the court is saying that if the woman is wearing such dresses which are sexually provocative, that prima facie, that means at its face value, in the trial it may be found that section 354A is applicable and the accused can be punished. But at least at this stage, without trial, we can't hold that section 354A is attracted because the woman was wearing some sexually provocative dresses. Now the point is, section 354A only talks about when a man is initiating the requesting some sexual favor from a woman, or the man is initiating the process of physical contact with the women. But section 354A does not mention what will happen if a woman by her dress or by her actions indicate that I am ready. Now what kind of readiness that the woman is showing is a matter of subjective judgment. But if the woman says that yes, I am ready, and if the man approaches her and says okay, I am also ready, then what will happen? If the first cut is cut from the women's side, then what will happen? Now the court has made this statement to my mind in this context, that when a woman is acting in a way which is giving indication to a person that yes, the woman is ready, perhaps to have sexual intercourse or for a chat, and if the man approaches, then what will happen? Now the point is it possible by seeing the photograph of the women wearing some dresses and reached to the conclusion that the women was indicating by her actions that he is ready, that she is ready? I think that is a question. But I believe that this judgment give birth to a question of law, that what will happen when the first cut is made by the women and then a man approaches. Now the point is, the court has further stated, and I quote, even admitting that there was a physical contact, it is impossible to believe that a man having age 74 and physically disabled can forcefully put the de facto complainant in his lap and sexually press her breast. Now the court has said that is it possible to believe that a man whose age is 74 can force a young woman? I believe that our Prime Minister, our present Prime Minister, is 71 years old. And I dare to say he may be much more fitter than many of us. And I don't wish to say much more. But the court has also stated that the man is a physically disabled man. Now the court has not mentioned in the judgment that the accused man has provided any type of medical certificate to corroborate that he is a disabled man or he was physically disabled at the time of the commission of the alleged offense. The time of the alleged commission of the offense. Now these two observations, namely that it is impossible for a 74-year-old man to force a woman and the man is physically disabled, I believe these two statements are out of the context, is out of the place. But why the court has not appreciated section 354? Because if physical contact, if prima facie the court believes that physical contact is absent, criminal force will also be absent, because a person who cannot even touch, how can that person can force a woman? So the point is this: the court has made this statement that section 354A is inapplicable, at least prima facie it is inapplicable, because perhaps the indication that the woman is ready has come from the woman itself, from the woman herself, and the man has approached, perhaps. But making this statement that it is impossible for a man who is 74 years old to force a woman is out of place. And I must say that it is true that bail is the rule and jail is the exception. But we must say that considering the age of the man who is 74 years old, the court perhaps have done right by granting the bail. And the court perhaps may have done right by saying that when the first cut is initiated by the women, if there is a possibility to hold that the first cut has been initiated by the women and then the man approaches, then what will happen? And I believe that the court has said it wrong when it stated that the moment a man becomes senior citizen, he becomes unable to generate force, and considering a man physically disabled based on his age, his prejudice shows biasness and nothing else. And I trust that we should understand, debate the context first. and then the statement. So therefore, I conclude by saying, let us appreciate the consequences of reading, of appreciating half, because halfly read is not only wrongly read, but it is dangerous for the society at large.